We're talking about Target and the revised number of people affected by that data breach, 70 million. That's just mind-boggling.
Now to your money tonight, and after that major data breach, your personal information, Equifax is now paying a record amount. The credit reporting agency now agreeing to pay up to $700 million. In fact, millions will go to American consumers.
If a developer who people gave their information to, in this case Alexander Kogan, then goes and in violation of his agreement with us sells the data to Cambridge Analytica, that's a big issue. And I think people have a right to be very upset. I'm upset that that happened.
I didn't play those clips to scare you, but to introduce the tone of the next few minutes that we're gonna spend together. As with everything in life, there's a yin and a yang. Building a company that helps agents, independent agents, use and leverage their data has a ton of innovative and exciting opportunities, which we're gonna talk all about, but also comes with a very deep responsibility. And that topic of responsibility has come up in meetings over the last couple weeks. Now, what I've noticed is that, yes, people want to safeguard their partnership, their collaboration with us by making sure that we're a business that takes seriously data privacy and security. But what I've also noticed is that they're asking these questions because they don't know, because they want to do the same thing and they're not sure how to do it. So in the spirit of transparency and taking you guys on this journey with us, I want to share what we've learned, because I know this piece of legislation is going to be a catalyst for so many businesses in the US, and it's one of the most important pieces of law that's been passed in the last couple decades on data privacy and security, and has some really actionable steps that businesses can take. I'm gonna start here with the California Consumer Privacy Act of 2018, also known as the CCPA. So remember that before the CCPA, there really wasn't any updated or meaningful legislation on data privacy and security, at least as how we're using data stands now in 2019. Nothing that helped steer data and technology companies in a direction that protected the consumer. It was like the wild, wild west. You just made up the rules as you go. Here's Alistair McTaggart. McTaggart? Really hope I got his name right. The real estate guy, yes, real estate guy, who created the CCPA, explaining his experience with big data companies and regulation.
I mean, how many times have people told me, don't kill the innovation engine of America? We know best. Don't let the civilians come in. Don't let the government people come in, because they're going to ruin our business. Just leave us alone. We're really smart computer scientists, and we know how to do this. And this is much too complicated for you. Well, I'm here to say I'm not a buyer of that narrative.
I mean, who would want to give up complete and utter freedom for government oversight? I get it. But here's the interesting thing about how the way in which the CCPA was created. Whereas the GDPR, and if you don't know what the GDPR is, I don't know if we can be friends, says companies can't collect and use data without first getting the explicit permission of consumers. The CCPA says companies already have implicit permission to collect and use data. But, you were waiting for the but, the consumer has a right to stop it. So with the GDPR, consumers start the process. With the CCPA, consumers stop the process, which to me is such an interesting way to craft the legislation. It's almost like they looked at the GDPR and says, you guys messed that up. Like, what were you thinking? We're gonna do it this way. And then went and created it the complete opposite way. I don't know if it's just because we're Americans, we gotta do it different, but think about it. This regulation isn't putting mass brakes on every California company saying, stop, you can't collect and use consumer data anymore. Just everybody stop doing that. What it is doing is giving the consumer, the individual California consumer, the power to act through transparency. That's just a smart way to create the law from an enforcement standpoint. If you've been following the GDPR, you know that Ireland, being the country that's supposed to be the enforcer of the GDPR, hasn't been as effective as maybe we might have thought. I'm sure partially because it's overwhelming to think that you've got to go out and tell companies to stop doing something. But B, because think about how much pressure there is on a consumer to solve that ultimatum. You have a decision to make when you come to this website or when you do business with this company. Either you tell them they can or you tell them they can't. Blank statement, ultimatum. That's a lot of pressure for a consumer, and once that trigger point has passed, then what? Versus the CCPA, which is really focused on helping consumers just understand what's going on. How is their data being used? What data is being used? And through that knowledge, make an informed decision on how to act at any point in time on their timeline, not in this pressure-filled situation where the business is forcing an answer from them. Honestly, I really dig America right now. Okay, so I think to understand everything that I'm explaining, and I may have jumped the gun here, but let's get into how this thing actually works, and that'll provide some more context to what I'm saying. Because the CCPA is all about empowering the individual, it's essentially a series of rights, 5 total. The right to notice, the right to know, the right to delete, the right to opt out, the right to not be discriminated against. Okay, let's go through those one by one. If you followed the GDPR and you've got that little pop-up notification on the bottom of your website that notifies people you'll be placing a cookie on their browser and goes into a little bit more detail on your data usage policies, then you're basically good to go with this first right. Essentially, it's the right of a consumer to be notified about whether and if a business is collecting and using their data. The right to know takes a deeper dive into the right to notice. So instead of just giving that high level, hey, we're notifying you that we're collecting and using your data, the right to know says a consumer has the ability to contact a business either by a phone number listed on their website or a form on their website and ask that business what specific information, what specific data is being collected about them, the sources of that data, how it's being used for business or commercial purposes, and what third parties it's being transferred to, if there are any. So on June 2020, a consumer can call you or through a form on your website, put in a request to get that information, and you have to answer them within 45 days. This one is exactly what it says. At this point, the consumer has been notified that you're collecting data. They've asked specifically what data is being collected, and they've made a decision to act on that knowledge. They want you to delete the data. They don't want you to have it. Now, unless your business needs that data for agreed upon, between you and that specific consumer, agreed upon goods or services, unless you need the data to finish that off, you have to delete it. And here's the kicker, you have to make sure that any third party who has that data also deletes it. They snuck that one in there. This fourth one to me is probably the most interesting. Let me give some context. So the bill essentially breaks a business's engagement or interaction with consumers into 2 buckets: collecting their data, selling their data. Now, we're going to go over this in a sec. The definition of selling your data is a little bit broader than what you might initially think, but just know for the get-go that those are the 2 buckets. The right to delete really takes care of this first bucket, right? You've collected it, they've asked you to delete it, we're all good. But there are companies out there who are doing more than just collecting the data. They're giving it to other people and getting monetary reimbursement for that. What if a consumer understands that if they've given a company their data because they want the best experience possible from that company, and they know that by the company having that data, that relationship with them, that improves their customer experience. But what they don't want to happen is for that company to then go and monetize their data, right? Go make money off their data, which is essentially what online advertisers do. This right to opt out essentially takes care of that second bucket. It allows the businesses, it's a consumer telling a business, hey, you've collected my data and I want you to keep that to improve my experience, but it prevents businesses from then selling the data to somebody else. Now with the right to know and the right to delete, a company just has to have a telephone number or a form on their website where a consumer can contact them. With the right to opt out, a company has to create, and again, this is only for companies that are selling data, but they have to create a separate page on their website that's specifically titled, "Do not sell my information." That's the page that's the trigger. It has to allow a consumer, a client, prospect to opt out of that business selling their information. All right, last one, super easy. Essentially, if a consumer says, I'm gonna activate my right to be notified, to know, to delete, or to opt out, you as a business owner can't discriminate against me as a consumer because I've taken that action. Boom. So those are the 5 primary rights that you need to be aware of, that you need to be thinking about, both for your business and for your clients' businesses. Now, to understand whether you're a business that falls within the scope of the CCPA, there's a couple key terms, 3 key terms specifically, that you need to understand. And those are business, personal information, and sale of data. These are the 3 terms that are pivotal in this bill. And because they've taken such a broad definition for each of them, they're actually under attack over the next, have been and will be over the next couple weeks until we get the finalized bill by tech companies and data companies. You might think off the bat that business should be defined as only businesses physically located in California. If only. The way this bill defines business is any company, any legal entity that is collecting or selling the personal information of California consumers. Which is why my partner's company, Sleep Number, which is headquartered in Minnesota, because they sell beds to people in California, because people from California come to their website, they're collecting data on them, they have been talking about this bill and how to make sure that they're staying in line with it. Now, in addition to being a business as defined by the bill, you also have to meet one of 3 criteria. Have $25 million in annual revenue, possess the personal data of more than 50,000 consumers, households, or devices, and earn more than half your revenue through the sale of personal data. As a small business, the first and third ones might be pretty high thresholds, but that second one is a lower bar. Think about it. If personal data is defined as IP addresses, and we're going to go through what personal data is defined by in just a sec. It is a broader definition, so if it's defined as IP addresses, and you're collecting 137 IP addresses, 137 people are coming to your website every day. 137 times 365 is 50,005 IP addresses, which falls under the scope of a business that needs to follow the CCPA. Just things to think about. Off the bat, real name, email address, phone number, home address, social security number, driver's license number. And the answer is yes, and it also includes commercial information, internet activity, geolocation data, biometric data, educational data, and professional data. Little bit of a broader approach than you might think. So again, if somebody comes and says, I have the right to know and the right to delete and the right to opt out of the personal information that you're collecting on me and using on me, all of this data falls under that scope. A normal person would think that sale of data means, yeah, this guy over here and this gal over here, this guy's got data, this gal's got money. This guy gives the gal data, this gal gives the guy money. Boom. That's the sale of data. Unfortunately, Californians don't think that way. It's defined as selling, renting, releasing, disclosing, disseminating, making available, transferring, or otherwise communicating orally or by electronic or other means. So basically, letting it out of your site in any way, shape, or form. You know, I thought Webster and Merriam were pretty smart guys, but California. All right, to wrap this up, I'm gonna give you guys 2 action items, 2 things that you can do today, tomorrow, next week, before June 2020 to help make sure that you're prepared for this bill. Look, I seriously doubt that on June 1st of 2020, a consumer, your neighbor, is gonna come knocking on your door or calling up your company demanding their data. And depending on the size and type of your business and your client's business, you probably are out of the range of fire. We all know this bill was made with a very select group of companies in mind. But having said that, handling people's data is something that we do on a daily basis. And that's not gonna stop. That's gonna become more and more and more true. So being aware of what's expected of us and how to react to it helps keep our businesses and the businesses of our clients safe. Plus, it shows people that you work with who probably have some fear of what companies are doing with their data, as you do, as I do, as we all do, that you're taking this seriously and you do truly care about protecting their privacy. I don't know what better way to stand out in 2019. So action number 1, take a look at your data inventory and ask yourself whether you're selling data, what third parties you're transferring data to. And yes, that includes the Facebook pixel. Whether any information is covered under HIPAA, the FCRA, the IIPPA, or any other law that would exempt that data from the scope of the CCPA. And finally, whether that data was collected more than 12 months ago, because that makes it potentially exempt as well. Action number 2, update your business processes. I mentioned my partner's company Sleep Number a few minutes ago because we've been talking about the CCPA, and it's something that her company is intentionally adding as a topic to different meetings as well as quarterly calls. They want their team to be aware of what's happening and how the company is making sure they're staying on top of it. Again, I don't know that this is going to happen immediately next year, but what if a consumer does call your business and ask for specific information, activating their rights within the CCPA? The worst experience that they could have is talking to someone at your business who has no clue what they're talking about. Second, if you do fall under the scope of the CCPA, or if your client's businesses do, make sure you got that telephone number, make sure that you've got that online form, and make sure you're ready to put up that "Do Not Sell My Information" page on your website. Wow, okay. If you have made it to this point in the video, I am so impressed and also have literally no concern about you and the CCPA. So congratulations. You now know way too much information for any cocktail party over the next 10 months. Having said all that was said, know that this is the very first, as in the very first, piece of legislation that has ever been created in the country that's equipped to effectively, impactfully deal with data usage as it stands today. It's literally the rookie bill, which means that over the next couple years, it's going to change. In fact, this isn't even the final bill. In the next couple months, we're supposed to get the final bill from the Attorney General of California, which will be what goes into effect on June of 2020. So the key terms that we discussed earlier, the fact that they're so broad, those could potentially narrow. I seriously doubt anything is going to get broader, but things could become a little bit more narrow over the next couple weeks. We'll see. Now, not only does it have the potential to change over the next couple months, but as cases go before the judicial branch of our government, the law will start to grow some serious roots as precedence is created. So depending on how different judges interpret the law, it could take on different meanings for different industries, in different situations. There's a whole breadth of unknown that we don't have a grasp on yet. This is literally the skeleton and the bones, and it's going to take more shape. It's going to get filled in more. It's going to be colored as people start to live with it. Just a really quick example is Facebook's interpretation of the sale of data. They don't actually believe or want to believe that they are selling or transferring data, even though they're an online advertiser, right? In its simplest form, what they're doing is taking personal data, selling it to advertisers, and then giving those advertisers the ability to put information in front of consumers based off of that data. But, there's a but, what they're actually doing is collecting personal information, sending it to an algorithm. The algorithm is producing insights, and not even those insights are really given to advertisers. The insights are kept secret and used to showcase advertiser material. So the question being, are advertisers paying to access the algorithm or paying to access the data? Depending on how a judge interprets that case, when it goes to court, could seriously impact how our society views data privacy and what standard businesses are going to be held to. So my biggest takeaway for you is don't stop paying attention.